Hello, I am Michael Sneeberger. I'm an attorney licensed to practice in Arizona and Minnesota. I obtained my CIPP designation in 2010, CIPM in 2014, and I'm currently in a computer science master's degree program at Arizona State University. I also work at a large financial services outfit in the data privacy space. I recently came across a hypothetical used by a major player in the Adtech space as a basis for presentation job interviews for data privacy attorneys. Given that presentation interviews seem to be the new thing, and given that the ad tech space is currently undergoing some big changes with the hopeful demise of third-party cookies, I thought running through the hypothetical would be a good way to set a California privacy baseline of current conditions so that practitioners might have a launching pad for how CPRA amends CCPA and how both of those look at cookies and those involved in the cookie-based ad tech environment. I won't read the hypothetical word for word, but it's about a fictional company called GingerSnap that, in conjunction with publishers and destination partners, creates what the hypothetical calls a match graph using hashes that are a combination of the publisher destination partner website user email addresses, GingerSnap's own cookies, and the cookies set by the publishers and partners on their own websites. This match graph will allow GingerSnap to sell onboarding services to clients who wish to advertise to their own customers when those customers visit other websites appearing on GingerSnap's match graph. This is facilitated by GingerSnap's clients providing the email address of their own customers to GingerSnap, which then creates a hash that's akin to the ones in the match graph, which ultimately allows GingerSnap clients to utilize ad tech technology to present ads to their own customers when those customers visit other websites. The hypothetical does not mention it specifically, but GingerSnap's clients could also use just the fact that their customers visit these other websites as intelligence for their own direct marketing activities. If one was presented with this hypothetical as a basis for a presentation interview, the goal would be to explain four things in particular: how each participant is classified under CCPA, whether there are any sales of personal information occurring, the obligations of each participant, and the rights each party should offer to the consumer. Given that we're only 1 year away from the implementation date of CPRA, I'm going to go ahead and extend my analysis not only to CCPA, but also to CPRA. In order to make it easier to identify the CPRA materials on my wall of text slides, I'm going to make the CPRA materials in yellow so they stand out a little bit better. Keep an eye out for the new characterizations of contractor and the new activity of sharing. CCPA and CPRA only care about personal information. And although these statutes have some drafting issues, I really think their definition of personal information and definition of de-identification are great in that they are about as broad as possible. And that means that personal information includes probabilistic identifiers, which would be the category which would consume fingerprinting. And it also includes that pseudonymized information is still personal information because someone somewhere could reattach the identity of the consumer to the data. And it also incorporates into the definition of personal information unique or personal identifiers, which would be things like IP addresses, cookies, pixels, and in other words, things that Adtech uses as identifiers. With only truly de-identified information being excluded, and that means that the data can never be reattached to any particular consumer by anyone. That's the only exclusion to personal information under CCPA and CPRA. CPRA adds a new category of sensitive personal information, which is a subset of personal information, and includes things like Social Security or other identification numbers, financial information that includes the access codes to use that information, social data such as racial or ethnic origin or religion. As described, the hypothetical does not include sensitive personal information, so we do not need to visit any of the additional requirements presented by the CPRA for sensitive personal information. I am going to start my analysis by running through an overview of applicable CCPA and CPRA concepts, then outline the assumptions I make, and finally analyze the hypothetical. Let's start by taking a look at what activities or behaviors CCPA and CPRA care about. The actions listed here are pretty self-evident, but one that many overlook is the extension of the right of the user to opt out of sale of personal information by way of their use of the global privacy controls, or GPC, which are available on some browsers. In addition, CPRA has added some new activities, including sharing, which was intended to clarify what I already think was clear, which is that the definition of sale, which includes the description of selling as including transferring a consumer's personal information by the business to another business or third party for monetary or other valuable consideration, which somehow some have read to mean that trading data for advertising without the flow of actual cash was not a sale. The new CPRA definition of share and treating share just like a sale clears this up. CPRA also formalizes two concepts which everyone should already be doing anyway. One is minimization of data collected to that needed to achieve the purpose for which it was collected. And in addition to the base threat of a private right of action under 1798.150, a basic requirement of the implementation of reasonable security procedures and practices. It will be very interesting to see if Ashkan Soltani and the CCPA has the resources and funding to go after companies for these two requirements. Also, see my law review article, the citation of which is listed on the last slide, about how CPRA enforcement will be moving away from private rights of action and back to government enforcement in light of the Supreme Court of the United States' recent TransUnion decision. Even though CPRA implementation is a year away, if your organization is not already minimizing the PI it collects, you need to get on that right away. CPRA has slightly adjusted the definition of a business to which the statute applies and has widely expanded what a business contract with a service provider must include. But perhaps the most vexing addition made by CPRA is the new category of contractor. While both a service provider and a contractor status is based upon having a contract with a business outlining limitations on what the service provider or contractor may do with the personal information sent to them by the business, the differences between the two is that a service provider processes information for the business and a business merely makes personal information available to a contractor, with the contractor having the extra burden over a service provider of having to certify that it understands and will comply with the contract's limitations. Who's the target of this new contractor classification? Whether a transfer is a sale appears to be the key. When a business transfers personal information to a service provider, no sale is deemed to have occurred, as the service provider is contractually limited as to what it can do with the data. Whereas when a business transfers personal information to a third party that is not contractually obligated to those limitations, a sale is deemed to have occurred. Under CCPA, there was an exception to the definition of third party that included contractual limitations, and it is this exception that has been moved and now provides the basis for the new contractor status under CPRA. That is, an entity that receives personal information from a business but does not process that personal information but agrees to the same contractual limitations as a service provider now means a sale has not occurred when they receive personal information. So what's an example of a contractor under CPRA? Let's say you are a company that takes orders for products, then has the fulfillment of those orders performed by the manufacturer of those products pursuant to a contract that limits what the manufacturer can do with the personal information you forward them to facilitate the fulfillment of the orders. For example, name, address, perhaps telephone number. In this case, the manufacturer would be a contractor under CPRA. With the appropriate contract in place, transferring personal information to a contractor is not a sale. But without the proper contract in place, transfer to the manufacturer would be a transfer to a third party, and that would be a sale. All right, let's finally get back to the hypothetical now that we've run through a general outline of the provisions of CCPA and CPRA that are applicable. We need to make some assumptions so that we can analyze the hypothetical. The first one is that by send an audience to the destination platform for cookie-based advertising, the hypothetical means that the Adtech system serves customers client ads when they visit the publisher or partner's site. The second is that consumers are natural persons who are residents of California acting on behalf of themselves. Third is the consumer uses their personal email address as their username for logging into the publisher or partner's websites. Number four, we do not know if the various participants independently qualify as a business which is subject to CCPA or CPRA. Number five, GingerSnap receives hashes of emails from partners other than the publisher in addition to those partners, allowing GingerSnap to set cookies, thus allowing the creation of cookie sinks. In other words, the partners, in addition to the publisher, are treated the same. 6, GingerSnap pays or otherwise provides value to publisher and partners in exchange for receiving the hashed emails and being allowed to set cookies. As we mentioned above, this matters for CCPA but does not matter for CPRA. Number 7, no party has a written contract with another party limiting the use of transferred personal information such that any party is deemed a service provider or a contractor. And finally, GingerSnap's product and service will survive through the enforcement of CPRA. Let's take a look at the various participants. We can go through this pretty quickly because this is pretty straightforward. The consumer is who logs into the publisher or partner's websites and includes their email address as part of the logon procedure. The publisher and partner run websites, and they are part of the supply side of the ad tech. In other words, they provide spaces for ads to be inserted. GingerSnap is the subject of our hypothetical in principle, in that they receive a hash of the consumer email from publisher and partner and make their match graph so that they can then have the last category here, which is client, which is someone that wants to be able to place ads in websites when their own customers visit those other websites. Now let's take a look at the data that's involved in the hypothetical. And the first is the email address of the consumer. This is clearly personal information as it's associated with an individual. We also have the hash of the email address of the consumer. And this is still personal information because the hash does not meet the definition of de-identification, particularly on the facts of this hypothetical. And then we have the combination hashed email, GingerSnap cookie, and destination partner cookie. This is still personal information as the processing outline does not meet the definition of de-identification. And this is also a unique identifier or unique personal identifier, which is a classification that's subsumed by reference into personal information. GingerSnap cookies are personal information again, because this is associated with a particular individual, and the partner cookies are also personal information as they're associated with a particular individual. We mentioned earlier that there could be sensitive personal information involved in CPRA. That is not applicable in this hypothetical as the way it's given. And data minimization is just something to remember based on the fact that the hypothetical says that GingerSnap is going to own the data that's in the match graph forever. And part of minimization is only keeping the data for as long as you need it to provide the service. Now let's take a look at the classification of participants in the hypothetical. The publishers and partners act exactly the same, so we will talk about them together. If they're a business, meaning they meet the requirements of the definition of a business under CCPA, then they have a duty to provide notice to consumers regarding the information that they will collect and what they will do with it. And they will also need to provide an ability for those consumers to opt out of the sale of that information. There's a particular requirement for younger consumers. So if someone has reached 13 years of age but not reached 16 years of age, then they switch to an opt-in regime as opposed to an opt-out regime. And then remember that CPRA says that we should only collect the consumer information that's reasonably necessary and proportionate to achieve the purposes for the personal information was collected. And finally, we get to, which is a little bit of an odd facet, if the publisher or partner is not deemed to be a business pursuant to CCPA or CPRA, then they do not have any of those above obligations. Continuing our look at the players in the hypothetical, the consumer is obviously a consumer, but there are some exceptions under CCPA that go away from under CPRA. For example, if the consumer is logging into a publisher or partner's website as an employee or an applicant, then they are exempted from CCPA, but this exemption will cease once CPRA comes into effect. And similarly, if they are logging into publisher or partner's website as the representative of a business, then their information would be exempted from CCPA coverage, and this exemption will also disappear under CPRA. All right, let's get to the meat of it. Let's look at GingerSnap. If the assumption that the consumer emails were collected by the publisher and partners only as a usernames is correct, then GingerSnap is not a business in the hypothetical. But if they were collected on behalf of GingerSnap, then GingerSnap could be a business. And if GingerSnap is a business, it would have the duties of a business under both CCPA and CPRA, including providing a privacy notice and facilitating a right to opt out of sale of the consumer's email address. However, there is a strange twist in that if GingerSnap is also a data broker, as it collects and sells personal information on consumers with whom it does not have a direct relationship, Regulation 999305E provides that a data broker need not provide notice of collection to consumers if it has registered as a data broker pursuant to 1798.99.80 and included in its registration a link to its privacy policy that includes out the opt-out facility. So that's a little bit of a twist there. Now, if we continue to look at GingerSnap and assume that they're not a business, let's take a look at if they're a service provider. If we've assumed, and we have, that there is not a written contract between the publisher or partners and GingerSnap, which means that GingerSnap is not a service provider. If there was a contract between publisher or partners and GingerSnap, GingerSnap could be a service provider under CCPA, but it could not be under CPRA, as CPRA requires the contract between the provider of the personal information and the service provider to prohibit selling or sharing the personal information, which GingerSnap does in this hypothetical. How about contractor? We've assumed here again that there's not a written contract between the publisher or partners and GingerSnap, which means that GingerSnap is not a contractor. But even if there were a contract, GingerSnap could not be a contractor under CPRA because similarly, it requires that the contract prohibits selling or sharing the personal information, which GingerSnap does in this hypothetical. So that doesn't work. How about third party? Yep, as GingerSnap is neither a service provider or a contractor, then GingerSnap is a third party, even if they are themselves a business in another scenario, not related to this particular data. GingerSnap's status as a third party is important because under 1798.115, it says that a third party shall not sell or share personal information about a consumer that has been sold or shared with a third party by a business unless the consumer has received explicit notice and has provided opportunity to opt out of that sale. That means that unless publisher and partners privacy notices and right to opt out of sale are in order, GingerSnap cannot transfer the personal information collected from publisher and partners users and use it in the Adtech system. Now let's take a chance here and add a couple of players into the hypothetical that were not there, just to see where that takes us. How about the internet service provider or the website host company of the publisher or partner? If they're a business, then the ISP would have the duty of a business if it independently collects personal information, but not here, because they're not the one collecting the information. If they're not a business, then the potential status of another classification must be investigated. Are they a contractor? This is possible, as it could be deemed to simply, under CPRA, to just have the personal information made available to them and they're not actually processing it. But there'd have to be a very specific contractor in place. I don't think they're a service provider, as the ISP does not process the personal information of the publisher's users, as the login procedure is done by the publishers and partners. How about a third party? If the ISP is not a business and it's not a contractor, then the ISP is a third party. But the transfer of data would not be a sale, as it's not for value, and it would not be a share, as it is not for cross-contextual behavioral advertising. So it's not a sale under either CCPA or CPRA. How about, since the client of GingerSnap gives customer information, how about the customer relationship management software provider of GingerSnap's clients? Again, if they're a business, then they would have the duties of a business if they independently collect personal information, but not here because they're not who's collecting the information. But if they're not a business, let's take a look at the potential classifications. Are they a contractor? Yes, but that's effectively overwritten by the CRM status as a service provider. The service provider answer is yes, because they are provided the personal information and they process that personal information under a written contract between them and GingerSnap. Now note that their status as a service provider could be ruined if the underlying contract does not sufficiently limit their use of the customer PI. They're not a third party because CRM is a service provider, which means CRM is not a third party. So let's get to the ultimate question: is there a sale involved in any of the exchanges in the hypothetical? And remember, there's a sale is any selling, renting, releasing, disclosing, disseminating, making available, transferring, or otherwise communicating orally, in writing, or electronic means consumer's personal information. And the consumer does not direct the business to intentionally disclose the personal information to someone else. And the business is not using the personal information simply to affect the consumer's opt-out of sale, and the transfer of the information is not part of a merger, acquisition, or bankruptcy, or something like that. Sharing, as introduced in the CPRA, addresses transfers just for cross-contextual behavioral advertising, whether or not for monetary or other valuable consideration, which clarifies that trading personal information for reciprocal advertising is covered by CPRA. So ultimately, in the hypothetical, if no additional participants are introduced, then each transfer of the personal information is a sale under CCPA. But under CPRA, the transfer would be a share if the assumption is that GingerSnap pays the publisher and partners for email hashes and cookie setting rights is incorrect. But assuming GingerSnap pays for the personal information and publisher partner consumers, it is a sale under CPRA. But sales and shares are treated the same, so the distinction has no effect. Additionally, if we add in the CRM is considered, then CCPA's client provision of personal information to the CRM provider is surely not a sale, as the CRM would be a service provider by way of a contract. So that is where we ultimately end up. And I hope that this was a nice discussion to get practitioners in the data privacy realm, specifically exposed to California, thinking about Adtech and how the players in Adtech are viewed by both CCPA and CPRA, and how the data that's flowing around in an Adtech regime is looked at by CPRA and CPRA. If you're interested in data security standards that are applicable in California, take a look at my law review article that came out in October of 2021. The citation is here on the bottom. Thank you very much.